So good afternoon, everyone. Welcome back to our weekly webinar series on IBC. And this is the first time that we are doing it pre-lunch. We're doing it 1 p.m. And this new time, it seems, is suiting more people, at least with the numbers that we are looking at today. The topics that we discussed till last time were very important with respect to all the changes that IBC is foreseen to undergo, and we discussed all that. Today, the idea is to get an update on what are the latest judgments on IBC, which are pronounced by the Honorable Supreme Court and the Honorable NCLAT. We are looking forward to discussion, questions, and an interactive session today also, and looking forward to close it in time for all of us to have our lunch with our families. Over to Anil, sir. He can start with the Supreme Court judgments.
Thank you, Ankit, and namaste to all the participants. This is 14th episode as we started weekly collective learning episodes. So we have been able to do till 14th without any break, and we wish that we continue like this. Every time a new subject, because this time we thought that some Supreme Court and some NCLAT judgments are very important, which are released in the last 2 months. So therefore we thought of this subject, and we are also preparing, and our team is also working on another very important subject, that is the responsibilities of the IRP, RP, and the liquidator for companies which are listed on stock exchanges, their responsibilities towards SEBI. That also we would be preparing, and shortly we will, because see, this has been a great demand. Everyone is asking for this because the clarity has to be there. Amendments are there from NSC, BSC, SEBI. So then we are trying to collate all that, and we would definitely be presenting it before you. So today we have certain landmark judgments on from Supreme Court, and one 5-bench judgment from NCLAT, which was a issue which was pending before NCLAT long back. So we definitely will go through. Me and Ankit collectively will elaborate on these plans. As we say, there are about 5 Supreme Court judgments, and there are about 4 NCLAT judgments that we have seen, which are important in the last 2 months. We will also be giving the dates when it comes on the. So starting with the Supreme Court judgments, Ankit, we start with this judgment of SS Engineers versus Hindustan Petroleum Corporation Limited. This was delivered on 15th of July 2022, and this was from Honorable Justice Indra Banerjee and Honorable Justice V. Rama Subramanian. So the the facts of this judgment is that the appellant was a contractor who was working with the HPCL, and on completion of the work, some notices were going on, some litigations were going on, and the appellant, who's a contractor as engineer, in fact, filed an application for insolvency of HPCL. So these are the facts, and like when we see these communications, the HPCL had sent some communications to SS Engineers giving details of the acts and omissions of the appellant, which tantamounts to breaches of contract on the part of the appellant. Despite several requests and reminders, the corporate debtor HCPL did not pay the amount due, but raised baseless allegations. These were the facts of the case. Later, due to defaults of the corporate debtor, the appellant filed an application under Section 9 of the Code for initiation of CIRP against HPCL Biofuel Limited. And I believe this is again a subsidiary company of a government-owned oil company. Then NCLT, in spite of pre-existing dispute, admitted Section 9 application on the basis that the claim default is for the higher amount and the dispute does not cover the whole amount. So the case was that the total claim of the appellant was higher, and when this NCLT saw the amount which was in dispute from various documents and also from the existing dispute which was also pending before Honorable Supreme Court, then the NCLT adjudicating authority saw that the dispute is for lesser amount and the claim is higher. Therefore, the NCLT thought that even if we see the dispute, still the amount is payable, amount has not been paid, and there is a default. That's what is the observation of NCLT. So then I think the corporator filed an appeal before NCLAT, and the honorable the appeal filed by HPCL, and it was allowed by NCLT, and the NCLT order commencing the CIRP was, in fact, it was set aside. Now the issue which was there, whether it is the duty of the Honorable NCLT to adjudicate the disputes between the parties and determine whether in fact any amount is due from the operational creditors or vice versa. No, I think the basic issue was that in this case, NCLT held that the amount of dispute is lower and the amount of claim is higher. That means that the NCLT in fact decided about the disputed amount and in fact started adjudicating on the disputed amount. So this is where the observation of Honorable Supreme Court came. It is the Supreme Court says that the NCLT exercising powers under Section 7 or Section 9 of the IBC is not a debt collection forum. IBC tackles and or deals with insolvency and bankruptcy. It is not the object of the IBC, and CIRP should be initiated to penalize solvent companies for non-payment of disputed dues. So this was the larger observation, that the CIRP of the solvent companies cannot be started only because of some non-payment of disputed amounts. Then there are noticeable differences in the code between the procedure of initiation of CIRP by a financial creditor and initiation of CIRP by operational creditor. It is also said that on a reading of Section 8 and 9 of the code, it is patently clear that an operational creditor can only trigger the CIRP process where there is an undisputed debt and a default in payment thereof. If the claim of an operational creditor is undisputed and the operational debt remains unpaid, CIRP must commence. For code does not countenance dishonesty or deliberate failure to repay the dues of an operational creditor. However, if the debt is disputed, the application of the operational creditor for initiation of CIRP must be dismissed. In this case, there was a pre-existing dispute with regard to the alleged claim of the appellant against HPCL or its subsidiary HBL, and NCLAT rightly allowed the appeal filed on behalf of HBL. It is not for this court to adjudicate this dispute between parties and determine whether in fact any amount was due from appellant or not. NCLT should not have admitted the application under Section 9. So, Ankit, any comments from you? I think this is very clear that if the NCLT decides that the amount of dispute is lower, the claim is higher, that actually means that the Section 9 mandate that the total claim should be undisputed, that was being contravened. So for all practitioners, the dispute, if there any kind of dispute, maybe for the entire amount, maybe for the part of the amount, dispute is a dispute. Dispute further cannot be analyzed to see how much is the dispute and how much is the claim. I think this is a very correct understanding of Section 9 and also the kind of responsibilities. I think the one observation of the Honorable Supreme Court that the solvent companies cannot be pushed to insolvency only because they have not paid disputed amounts to their creditors. That's what is the focus.
Yeah, so the idea, I believe, the only thing that I would like to add here is that it's important to understand, and many people would come to you and ask about guidance of the insolvency professionals or fellow professionals on how to handle any disputes that are going on. So all disputes should be well documented, and I think in this case, yes, there was this large dispute, but still they managed to get an order and take this government-owned subsidiary company to insolvency. So that is always the case, that using the NCLT as a recovery forum is again and again dissuaded. So NCLT is always observant that the company that we're taking into insolvency are they defaulting by conscious, or like is it just a dispute? Makes it further into the gray area. I think is further limited now.
Yeah,
based
yeah.
on this judgment.
So very well, I think we can move on to the next judgment, which is Vidarbha Industries Power Limited versus Axis Bank Limited. In fact, this judgment is also delivered from the same bench as the earlier, like it is again Honorable Justice Ms. Indira Banerjee and Honorable Justice V. Ramasubramanian. So these two judgments are delivered from the same bench. However, this particular judgment, which is Vidarbha Industries Power Limited versus Axis Bank, in fact, has brought into a new dimension of the difference between Section 7 application and Section 9 application. So in this case, the corporate debtor, which is Vidarbha Industries Power Limited, it's a generating company and is regulated and controlled by State Electricity Regulation Commission. Axis Bank is a creditor and filed an application under Section 7, subsection 2 of the code before NCLT Mumbai and for initiation of CIRP. Then the appellant, means the appellant filed an application seeking stay of proceedings under Section 7 of the code, because this was the application by Vidarbha that there should be a stay on this proceedings under Section 7 of the code. NCLT dismissed the application and refused to stay the CIRP initiated against the appellant. Therefore, the appellant filed an appeal before NCLAT. However, the same was also dismissed. Now, the issue in this case was, it was claimed by the appellant that the virtue of an order passed by the Appellate Tribunal for Electricity, which is APTEL, a sum of rupees 1,730 crore is due from the appellant. For implementation of APTEL order, it filed an application before Maharashtra Electricity Regulatory Commission. However, MERC has filed an appeal before Supreme Court challenging the order of APTEL. The said appeal is pending. So now what they are trying to say is the one that there was a amount which was payable by the electricity department, and that amount was due to the company. In case this amount could have been received, there could have been no dispute, no default by this company. The appellant, means the corporate debtor, contends that since the appeal of MERC is pending, it is unable to implement the directions of APTEL, and the appellant is in short of funds, and only the implementation of the orders of APTEL would enable the appellant to clear all its outstanding liabilities. Hence, the CIRP should be stayed till the pendency of MERC, means Maharashtra Electricity Regulatory Commission. So the contention was that there was one amount which was due from the State Electricity Authority. Appellate Tribunal for Electricity, in fact, passed an order for realization for payment of 1,730 crores to the appellant company, which is Vidarbha. That particular amount was not disbursed because there was an appeal filed before Maharashtra Electricity Regulatory Commission. Now the company says that had this amount received, had this application which is pending before Honorable Supreme Court is decided, that actually means this particular default would not have been there. The company, in fact, was trying to say that we are solvent. The Vidarbha is a solvent company. And in case this Supreme Court decides about this particular application, the MERC application, then this amount 1,730 crore would have been payable to the Vidarbha, and there would not have been any default. So they were trying to say that this their fund flow tightness is temporary, and in case this amount is released, there would not be any default, and they would be paying all dues of the banks, including Axis Bank. The NCLT and NCLT, in fact, proceeded that the application must necessarily be entertained under Section 7(5) subsection A. They were probably thinking that NCLT and NCLAT has no power to say no once they see that there was a debt and there is a default and the amount has not been paid. They have no other option except to admit the application. This is probably was the view of NCLT and NCLAT. However, this Supreme Court in this case, in fact, successfully tried to read out the Section 7, subsection 5, and also again Section 9, and they tried to differentiate. And subsection 5 says where the adjudicating authority is satisfied that A, default has occurred and the application under subsection 2 is complete, and there is no disciplinary proceedings pending against the proposed resolution professional, it may by order admit such application. So the Honorable Supreme Court has highlighted this word may. Actually, the word may provides a kind of discretion to adjudicating authority under Section 7 subsection 5 whether to admit or reject an application for commencement of CIRP. The B, default has not occurred or the application under subsection 2 is incomplete or any disciplinary proceedings is pending against it, may be or reject. So the word may again is seen as a kind of discretionary. So then they actually moved on to see actually what the word shall says. In fact, Section 9 was also referred, and in Section 9, it was the word may. And when they saw this Section 9, subsection 5, they provide that NCLT shall, within 14 days of the receipt of an application of an operational creditor, admit the same and communicated decision to this OC and the CD, provided the conditions stipulated in Section 9, subsection 5, clause 1A to E are satisfied. NCLT must reject the application in circumstances specified in section so and so. Now, the legislature actually has in its wisdom used the word may in Section 7, subsection 5, and it has actually used the word shall in an identical section, which is Section 9, subsection 5 of the code relating to initiation of CIRP by OC. So therefore, the Supreme Court said, as far as this financial creditors are concerned, they actually have some more options. Whereas the operational creditors, they have no other options. So in case there is a default, the application of an operational creditor has to be admitted. So I'll give a couple of illustrations. Now, for example, in a case, maybe let's take an example that in this particular case itself, there may be a scenario that about 90% or even 80% of the financial creditors, they may work on a restructuring plan or a kind of scheme under Section 230 of the Companies Act, or they may even try to reach out to a conclusion or a resolution under pre-packaged insolvency resolution process. However, while they are trying to reach out to it, while there are evidences that they are almost reached out to that kind of resolution, one of the financial creditors moves an application under Section 7, and then the company the corporate debtor has all the rights to present their circumstances before the adjudicating authority, inform the adjudicating authority that there are other ways of resolving my stress and which is being done. In case those ways are acceptable and considered viable by the adjudicating authority, then this adjudicating authority has a discretion to reject the application. So this case, this kind of a case, I think it can even be applied to the PIRP applications, where some applications, earlier applications under Section 7 or under Section 7 were pending. Now, what we're trying to say that in case some application under Section 7 are pending, and on the other hand, the 66% of the financial creditors, they have resolved that they would like to go ahead with the pre-packaged insolvency resolution process. I think the adjudicating authority has an option now to reject CIRP application and accept PIRP application, because that may be more viable and quicker. With those objectives in mind, the Section 7 applications can be rejected by adjudicating authority if there are some better options available, or the company is likely to be revived of its own based on a couple of events, based on a couple of eventualities. Now, in this particular case, the Honorable Supreme Court thought that if there is a positive judgment from Supreme Court and this company gets 1,700 crore from the State Electricity Board or State Electricity Company, then this company would be completely a solvent company. So in case this insolvency of this company is started, it actually would adversely impact all the stakeholders. It is rather better to wait for that order of Supreme Court. And in case that money is payable to the applicant Vidarbha, then it will be a very, very win-win situation for all. So therefore, for all equity, for the benefit of the stakeholders, the Supreme Court decided not to go ahead for the insolvency process. So this is what is, Ankit, I think the difference between the OC and FC is all that I've explained. This is what is the Supreme Court held in this case. Anything that you would like to add?
I think that's right. So, it basically establishes that there's discretion with NCLT with respect to financial creditors. Now, how that discretion can be used by NCLT to protect solvent companies or protect companies where there is a genuine reason why there is a default or there is an alternative which is being pursued. That is something which will depend on case-to-case basis, but at the same time, the speed at which maybe a CIRP process should start to safeguard the company from any exploitation by the management when it is actually insolvent, that may be derailed in case it takes too much time for whatever compromise or whatever alternative is being thought of. So I'm not sure how far and what would amount to usage of this discretion. That can be very, very wide.
See, we will request all the participants to please write their questions on this Q&A tab. We'll be able to take up the questions after this particular judgment, which is Vallal RCK versus Siva Industries and Holding Limited. It is dated 3rd of June, and it has been passed by Honorable Justice B.R. Gavai and Honorable Justice Ms. Indira Kohli. This again is an application filed under Section 7, was filed by IDBI Bank for initiation of CIRP of the corporate debtor. Application was admitted by NCLT, and then the resolution plan was also submitted by one Mr. Royal Partners Investment Fund, and it was voted before the COC. However, the plan was rejected by the COC as it received only 60.90%. Consequently, application under Section 33(1)(a) of Code seeking liquidation process was also filed. So in the meantime, the appellant, being the promoter of the CD, filed a settlement application before NCLT under section 60, showing his willingness to offer one-time settlement plan. So he approved the settlement plan by more than 90% of the voting share. Now, this is a unique case. A resolution plan is rejected. Now, the appellant, being the promoter submitted an application saying that I want to settle it, and it is the settlement under section 12 capital A of the code. And then the 90% voting was also assured. So it was kind of approved 12A application.
So the resolution was achieved through withdrawal of CIRP. Basically, that was the idea. Alternative resolution plan came in as that withdrawal of CIRP process. Yeah.
So like this, see, when we talk about this promoter's settlement application means withdrawal 12A, and that's what is settlement. Then the RP filed application before NCLT seeking withdrawal of the CIRP and approval of the settlement plan. However, NCLT rejected the same, holding that the a settlement plan is said plan is not a settlement simpliciter under section 12A of the code, but a business restructuring plan, and wide another order of the even date initiated the liquidation process of the CD. Now, maybe that it was not upfront, maybe it was a kind of payment in installments. So therefore, the NCLT thought that this is not a one-time settlement. So this is a kind of restructuring plan where some installments, some other options, or some other processes is defined in the plan. Then it was rejected by NCLT, so it actually went to NCLAT, and both the appeals, one the liquidation order and the other is the rejection of 12A. Both these appeals were filed. And the NCLAT, wider common judgment, NCLAT dismissed both the application. Now, when NCLT or NCLT can sit in an appeal over the commercial wisdom of the committee of creditors or not, when these are the issues, when 90% of more of the creditors in their wisdom after due deliberations that it is to be in the interest of all the stakeholders to permit settlement and withdraw CIRP. Now, the relevant law is section 12 capital A, which is withdrawal of applications admitted under section 7, 9, and 10. It was brought on the basis of Insolvency Law Committee report in 2018. The voting of 75% for approximately, it was brought down to 66% by the same amendment, this 12 capital A, the voting required was 90%. So this 12 capital A is kind of clearly defining the powers of the committee of creditors, that they have all the powers of allowing a withdrawal. That means setting aside the CIRP. That means company going back to promoters in case approval is granted by 90% of the voting share of the COC. Now, the section 12A further says the adjudicating authority may allow the withdrawal of the application admitted under section 7, 9, or 10 on an application made by the applicant with the approval of 90% voting share of the committee of creditors. Now, the observations of Honorable Supreme Court in this case was that the commercial wisdom of COC has been given paramount status without any judicial intervention for ensuring completion of the stated processes within the timeline prescribed by the code. Even in Swiss Ribbon Private Limited versus Union of India, it was held that if the COC arbitrarily reject a just settlement or withdrawal claim, NCLT and thereafter NCLAT can always set aside such decisions under the provisions of the code. There is an intrinsic assumption that financial creditors are fully informed about the viability of the corporate debtor and feasibility of the proposed resolution plan. They act on the basis of thorough examination of the proposed resolution plan and assessment made by their team of experts. This is what is the assumption whenever any stakeholder tries to see what has been approved by the committee of creditors. So again, the provisions of section 12 capital A was considered to be as final with the 90% of the voting, and any inference would be warranted only when NCLT or NCLAT finds the decision of the COC to be wholly capricious, arbitrary, irrational, or dehors. Then only the NCLT or NCLAT can intervene. But in case there is nothing negative like capricious, arbitrary, irrational, and dehors, then the commercial wisdom of committee of creditor is acceptable. It should be acceptable, and it should not be the jurisdiction of NCLT to say that it is a restructuring plan. It is not a resolution plan. It is not a restriction. It is not a one-time settlement. And so that's not the jurisdiction. The committee of creditors can even have an arrangement with the promoter that the promoter will give this much of money in, say, 5 years, 2 years, 3 years. It is not necessary that the one-time settlement means 100% amount has to be paid. So this is something which is the option now, which is available with the promoters, that if the resolution plans are not satisfactory, the promoter can definitely give an application under section 12 capital A, saying that this is the total amount that he would like to pay, allow him to run the company. So he will bring some investor, but then within 2 or 3 days, the promoter would be able to give the money, which is acceptable to the committee of creditors. So that option kind of, which we now see, that's a beautiful option, that one-time settlement may also include a kind of restructuring. So the decision of COC in this case, finally what Supreme Court held, that the decision of committee of creditors was taken after due deliberations, considering the pros and cons of the settlement plan, and took a decision exercising their commercial wisdom. Therefore, neither the learned NCLT nor the learned NCLAT was justified in not giving due weightage to the commercial wisdom of COC. The court has time and again emphasized the need for minimal judicial intervention by NCLAT and NCLT in the framework of IBC. Therefore, the appeal was allowed. This was the third.
Before we go forward, we can take some questions and maybe quickly answer them. So Sanjay ji is asking, what is the time limit within which resolution under section 12A can be passed, or withdrawal under 12A can be passed? I think 12A can be done anytime during the entire CIRP process. There is no time limit there. At any point in time, where after forming of the COC, at any point in time till the liquidation order is passed, 12A can be processed by COC.
See, earlier there was a confusion whether the RP has all the powers to conduct a COC meeting or not once the application for approval of resolution plan or application for liquidating the company has been submitted. Now in the proposed discussion papers and the proposed modifications in the CIRP, now it has already been made clear that the RP can have committee of creditors meetings even after the application for liquidating the company has been filed. So there has been many instances where the application under section 12 capital A was filed while the order for liquidating the company was pending before NCLT. So that means that any time while the CIRP is continuing.
But was it a 90-day limit also in the section?
No, there was no 90 days.
No 90-day limit. No.
There was no 90-day. Anytime it can be submitted, yes.
So, of course, it can always be withdrawn prior to the first COC meeting through the settlement of the applicant. That's also there, right?
No, there are two ways. One is that before constitution of committee of creditors, you can even the appellant. The appellant can submit form F, I believe, and that's what is the withdrawal of CIRP process. That's only by the appellant. But in case the committee is constituted, then it has to be 90% of the voting share.
So then we have a question from Srinivas G. He basically, the idea is that if any avoidable transactions, the puff transactions are pending with NCLT, even then can a 12A be processed? I think there is no limitation there.
There is no limitation, even if all these application transactions. But my understanding is very clear. Once this 12A is exercised, and that means the CIRP is process is withdrawn, the company goes back to promoters. So whatever has been done during CIRP, that actually will become nullified, including any kind of impact on the valuations, including the transactions application, non-cooperation application, all that actually will have no, it will actually become infructuous. So this is what is my understanding. And therefore, when this CIRP process is withdrawn, that means whatever has been done under CIRP process, that also stands infructuous. Any other question, Ankit?
Then we have a question from Mr. Arora. He's saying, what is the logic that 12A in 12A 90% is there, but approval of resolution plan is 66%? Because you're basically giving withdrawing the entire CIP process after the courts have decided that the company seems to be insolvent and needs to go through the CIP process. So therefore, there is a higher ratio for returning the company back to the promoters and back to the management as compared to processing a resolution plan. I think that's the only reason that there should be a reason, such a high difference between the two.
Yeah.
Then Sarika ji is asking that, is it right to say that 12A cannot be opted after approval of resolution plan? I think yes, so 12A needs to be approved by the creditors, and creditors in normal course or in any logical interpretation cannot approve 12A as well as the resolution plan.
No, I think I have seen cases. I mean, it is from Mumbai bench, and it is after about 14 months of resolution plan being approved, it was not finally approved by the committee of creditors. However, the bankers then thought that the resolution plan is not really giving us better realization. So the promoters offered something which is 25% higher than the resolution plan. So the promoter also offered amount all in lump sum, and it was also paid. So looking into all this seriousness, NCLT Mumbai in fact rejected the resolution plan, allowed section 12A even after the approval of the resolution plan, while pending before the NCLT for their approval.
Okay, all right. So that's something that will that will open another option for the promoters to take back the company even after all the processes gone forward.
Yes.
Praful ji is asking that after withdrawal under section 12A, who will pay the CRP and other costs? So there is a process, and it is always paid by before the application.
No, withdrawal is subject to payment of all fees and expenditure. If the fee and expenditure is not paid, withdrawal is not permitted.
So then we have, does that mean that promoter can give settlement proposal even after approval of plan by COC? Yes, that's what we're talking about here.
Yeah.
Then we have, if solvency is the crux in deciding section 9 application, then whether one should seek recourse in some other forum. Of course, other forums are open wherever there is a dispute. Didn't quite understand the question here.
Yeah.
Then a CD is generally in liquidity problem on account of non-realization of receivables from debtors. How can Supreme Court leave it to NCLT to decide on admission? This can be used by all promoters to delay the CRP admission. A comment from Sushil ji on the Vidarbha judgment. So, of course, maybe your perspective there can help everyone understand how it can be helpful or be damaging to all the financial creditor applications. Can it further delay and delay the admission of the applications by an FC now that this discretionary judgment or discretionary power has been established?
I think I gave a couple of illustrations where it was completely rationalized why such judgment has been passed. One illustration I gave that maybe there are 13 financial creditors, and out of the 13, 10 financial creditors, they are resolving the stress of the company on other forums, maybe for a restructuring plan, maybe for a pre-packaged, or maybe even for inter-creditors agreement. So in case they are doing it, and if one creditor with say small percentage of voting share can come to NCLT, I think it is the duty of the NCLT to see what would be more beneficial to company and the creditor. So if the creditors are already almost reaching a conclusion and that is a different forum. It can be pre-packaged insolvency resolution process. It can be inter-creditors agreement. It can be a restructuring proposal internally. It can be an investment from an overseas party. It can be an investment from a local party. But all these proposals are pending for some final approval. And the NCLT bench is convinced that this particular process which is going on in the company, they should be given another 2 months or 6 months time. And if that process would be accomplished, then the company would not remain as insolvent, and therefore the company would not come to us for all the creditors would be paid. So this is the logic. This is the logic, the illustration that I have given.
So let's proceed then. There are many questions. I will try and answer them separately, but we can proceed. Otherwise, we will be short of time.
So the fourth Supreme Court judgment is Indian Overseas Bank versus RCM Infrastructure Limited, again 18th May 2022, and it has come from Honorable Justice L. Nageshwara Rao and Honorable Justice Bhushan Ram Krishna. This is a case regarding the SARFAESI versus the IBC. In fact, the facts of the case are that before the commencement of CIRP, the creditor, the secured creditor, in fact, conducted an auction and finalized H1 bidder. H1 bidder has also paid 25% of the bid amount, which was 8.23 crore, and including the earnest money deposit. However, the balance amount, 75% amount, was not paid yet. In the meantime, the CIRP commenced. In the meantime, CIRP commenced, and the bank, in fact, hurriedly took 75% of the bid amount from the auction buyer and issued sales certificate to that auction buyer. Now, it was the question is that during CIRP, 75% of the amount was received. That means it was recovered, and the property was handed over to the auction buyer, and a sales certificate was issued. So I think it was very well contravening the section 14 of moratorium. So therefore, the NCLAT rejected the appellant, and therefore this present appeal before the Supreme Court. The issue which was raised before the Supreme Court was whether a bank can continue the proceedings under SARFAESI once the CIRP is initiated and moratorium is ordered. So as I said, that this is something on moratorium, so we should not read out all the provisions of moratorium or 238 and security realizations during CIRP, and we should only say that this is what was argued. Sale was complete on its confirmation before admission of the petitioner, relying on the provisions of Section 50. Transfer of Property Act provisions were also being noted. So finally, they were saying that the sale was complete. The respondent means the present, see, like this is the sale would be governed by the rules and regulations, that is security interest enforcement rules. The sale would be complete when the auction purchaser makes the entire payment and the authorized officer exercise the right to the power of sale shall issue a sales certificate in favor of the purchaser. In the present case, the balance amount has been accepted by the appellant after the commencement of the CIRP, and the moratorium was in fact already set in. Now, the observations in this case was, once the CIRP is commenced, the moratorium kicks in as per section 14(1)(c) of the code, and there is a complete prohibition for any action to foreclose, recover, or enforce any security interest created by the corporate debtor in respect of its property. The words including any action under the SARFAESI Act are significant. The legislature's intent is clear that after the CIRP is initiated, all actions, including any action under the SARFAESI Act to foreclose, recover, or enforce any security interest is prohibited. As per section 238 of the code, the provisions of the code should prevail, notwithstanding anything inconsistent therewith contained in any other law. Appellant bank could not have continued the proceedings under SARFAESI Act once the CIRP has initiated and the moratorium was ordered. The bank cannot continue the proceedings under SARFAESI once CIRP is initiated. Therefore, this was very importantly, the SARFAESI action was considered as unlawful, and the judgment was given by the Supreme Court that the sale certificate was invalid. So the asset came back to the corporate debtor. CIRP continued. Now this is the fifth judgment that we are deliberating today, which is regarding the new Okhla Industrial Development Authority, which is Noida versus Anand Sonbhadra. So this is a case which we fought as AAA Insolvency. Anand Sonbhadra is our senior partner. So we fought it right from the beginning at the C. This was the judgment passed by Honorable Justice K.M. Joseph and Honorable Justice Harishikesh Roy. So I have all the facts of this case, so I may not even need the PPT. So Noida, in fact, granted a lease of the plot in favor of the corporate debtor, and the name of the company was Shubkamna Build Tech Private Limited, and that was way back in 2010 for a period of 90 years. Then the CIRP started Noida 35 its claim in Form B as an operational creditor, attended the meetings of the committee of creditors as OC. Subsequently, Noida filed another claim in Form C, claiming to a financial creditor seeking voting shares in the COC based on the lease deed entered into between Noida and the corporate debtor. So NCLT held that this lease deed in question was not financial lease according to the Indian accounting standards. This is like this kind of arguments that we started, that let us take the facts of this case and correlate with the Indian accounting standard, and then we found that the Noida, it cannot become a financial lease, it is an operational lease. The NCLAT affirmed the view taken by the Honorable NCLT, therefore the Supreme Court appeal was filed. And this was the only issue, whether the appellant is considered to be a financial creditor and or the operational creditor. Section 8, of course, was very important for this, and it was the Section 8 financial debt. We should not read, but the argument from the respondent side was that the contrasting submissions were made stating that the case made out by the appellant how a disbursal can flow in either directions, ignoring that what is disbursed is a debt and not its repayment. Appellant had not mentioned in the books of account classifying the lease as financial lease. The lease in question could be constituted as financial lease since there was absence of substantial transfer of risk and rewards incidental to ownership of underlying transfer. So there are two issues. One issue is what is the financial lease and what is the operational lease as per accounting standards, and the second issue was what is the time that the risk and reward gets transferred. So these were the two things actually which was all. But then when we see this argument, finally the Supreme Court passed an order that any lease money or a lease premium, all are basically all are operational creditor. So there was some as per the Indian accounting standards, there is a lease which is considered to be an operational lease, and there are leases which are considered to be a financial lease, and the conditions in these leases, there are conditions, but then whatever Noida Authority documentations were there, in that particular documentation it was seen as operational lease and it was not seen as financial lease. Therefore they were admitted as operational creditors, hence this appeal. So all this, like when we see this the para 63 of Ind AS 116 was used, and we were successful in all this litigation. So finally the Honorable Supreme Court said that in this case it was an operational creditor. So there is no other relationship except the operational creditor. even this transfer of risk and reward was also discussed. So Ankit, now I think some of the questions can be taken, and also you can take up some of the CLT judgments.
Yeah, so I think
If I have
we still have another 10 minutes. So let me run through these NCLAT judgments. The first one is Prashanth Agarwal being the member of the suspended board of Bombay Rayon Fashions versus Vikash Parasrampuria. I will just quickly go through the issues. Maybe you can just allow, yeah, maybe go
or
through
see,
the
like
next slide.
maybe that in case you have the PPT with you, you can share your PPT.
Yeah, I can do that. Just a second.
Because you'll.
I will just do that.
You will navigate it better because the time is less and we actually have to just go through all.
Just doing that. You can. Okay.
I should stop share?
No, doesn't matter. Yeah, so I think everyone can see the screen now. So this one is the NCLAT judgments. The first one is Prashanth Agarwal versus Vikash Parasampuria. Now here in this case, what had happened was that the outstanding balance for after some delays and some payments, so the original balance was about 2 crore rupees for this OC, but after some payments, it went a little below 1 crore to 97.87 lakhs. And the question was that when it comes to looking at the 1 crore limit, will the NCLT also permit the addition of interest to gauge in case the prescribed threshold limit of 1 crore is being crossed or not? So the conclusion that came out was that if delayed payment is stipulated, the question was that if delayed payment is stipulated in the invoice or agreement, will the principal debt which is pending include the interest and therefore allow the OC to make his representation and file for insolvency. So based on the notification wherein this 1 crore limit was introduced, also looking at the minimum operational credit debt of 1 crore. Now in this matter, in this case, it was found that the interest on delayed payment was clearly stipulated in the invoice, and therefore it entitled the right to payment and therefore crossed the 1 crore threshold, because after interest it was making an outstanding of 1.6 crores. So therefore the application was maintainable, and therefore the NCLAT ordered the NCLT to pass the relevant order proceeding with the insolvency, proceeding with the initiation of CIRP in this case.
I think it's like one little thing, because it's very clear that when we file an application for an operational creditor, if the interest clause in the invoice is very clear, then we can add interest, and NCLAT has said that the adjudicating would consider, authority would consider the amount of default, including interest, whether it qualifies that threshold limit of 1 crore or not. Go ahead, Ankit, please.
Then we have Avanta Holdings Limited versus Abhilash Lal, which is for Jhabua Power Limited. Now, this is again something which we just discussed with respect to the 12-way plan. So in this case, the facts were different. The facts were that the promoter of the company, Jhabua Power, Avanta Power Infrastructure Limited, held 17.9% shares, and it had submitted a one-time settlement plan with the COC. The COC had rejected it, saying that it is commercially non-viable. And subsequently, the EOIs were issued, resolution plans were received, and there was this case where this NTPC became the primary resolution applicant. NTPC had two JVs which were held to be NPAs by Canara Bank. And the dates of those NPAs were important because if you read section 29A, it gives a 1 year margin or 1 year grace period for a company to set its NPA right before it becomes ineligible to present a resolution plan. So that happened here, that NTPC said that we have restored it, and even after 1 year, the proviso says that if at the time of submission of resolution plan, the NPA is addressed, then also the eligibility for the applicant to submit the resolution plan is retained. So in this case, NTPC had 29A. The question was that was 1 year through or was 1 year available to them? So eventually, the NCLAT said that the 29A in this case uh, was uh, was rectified, and the eligibility was available with NTPC when it filed its resolution plan, as it addressed the NPA issue with respect to its JVs in time. Also, this issue also involved a 12A application, which was rejected by the NCLAT, saying that you can't submit a 12A plan and insist on it. So in case you submit a 12A plan, the promoters submit it, and 90% of the COC approves it, then that's a different issue. But in this case, the arguments of the promoters was that the COC has summarily rejected 12A. However, the COC said that there was a basis for which the OTS proposal was rejected, as it was only offering 200 crores upfront, whereas the NTPC resolution plan was offering a 905 crores as upfront payment. So there was a significant difference in the upfront payment being offered by the resolution applicant and the promoters through the OTS proposal. So that's basically what happened then. So finally, basically the a resolution applicant's right was cleared off to take to be the resolution applicant, and the 29A claim was rejected, which was made by the promoters. Then next one is Jaipur Trade Expo Center Private Limited versus Metro Jet Airways Training Private Limited. This is the 5-member judgment that has been passed recently, and this 5-member bench was required to reverse a previous judgment which was causing a lot of issues for various operational creditors who had rendered some kind of service to the CD. And the judgment which was in the case of Mr. M. Ravindranath Reddy versus G. Kishan and others, this judgment has now been reversed and corrected. This judgment had limited the definition of services to a very minute definition, and this 5-member judgment has now reversed it. So it will be possible for OCs, for operational creditors who have a services claim, to now go to the court and say that we had offered some services, and therefore we are eligible operational creditors to initiate CIRP against the CD that has defaulted. In this case, the claim was with respect to license fees that was outstanding against an admin building, which was a warm shell building with fittings, fixtures, electrical flooring, and all that, which was given out to the CD on a license basis. So this is a landmark judgment. Yeah,
Ankit, it is very clear that this is a landmark judgment, and it only says that this rental outstandings. Earlier, there was judgment which was rejecting, saying that it is not an operational creditor. The rental outstandings are also considered to be the operational creditor. Therefore, the applications can be filed by all the landlords in case their tenants are not making payment of the rent.
So it is actually beyond now, because it kind of says that services has a very, very wide ambit. So basically all services, anyone who provides any services to any other person, now that open definition can be used, this judgment can be used by the applicant to say that the services are within the ambit of the supply of service, which makes somebody an operational creditor. So I will skip the rest of the decision. So basically come to the last judgment that we...
Rest of the content that we prepared, it is only regarding what was the earlier judgment. And earlier there were 3 judgments, and all the 3 judgments have now been overridden by the 5-bench judgment of NCLAT now in this case. So this is the final judgment, and I think all other may be even pending before Supreme Court, but before the Supreme Court decides, NCLAT also have decided.
So last judgment that we're talking about is Puneet Kaur versus KV Developers Private Limited. In this case, this was with respect to the belated claims of financial creditors of the operational creditor. This is a home buyer case, and some people or some of the home buyers had submitted the claims after 8 months from the initiation of the CIRP. And the claims of home buyers were showing in the books of the corporate debtor, but due to omission in filing of claims, the same were not reflecting in the information memorandum. So because the claims were not filed, it was missing in the information memorandum, and therefore there was also a lack of treatment of such dues in the resolution plan. So the first question was whether NCLT has rightly rejected the IAS filed by the appellant seeking directions to include their claims, which was belatedly filed. So there were these 4 issues that were talked about. So the first issue, of course, basically within NCLT, it was held that the first issue was discussed, and it was held that the list of creditors was already published by the RA, and it did not include the name of the appellant. And it says that the law as it exists today does not allow the list of creditors, or cannot include the resolution, the claims which are not received cannot be included in the list of creditors. That is the law that is set up today. This again, I think, is being thought of because this issue of belated claims is a large issue, and IBBI is trying to address it. Because one of the modifications that is being proposed is that the liability of the resolution professional to look into the books of accounts and identify creditors who have not filed their claims, and inviting them to file their claims is one of the liabilities or one of the requirements that is now being added for the resolution professionals. Then issue number 2, whether after approval of the resolution plan by COC, the claim of the applicants to distinguished. So it relied on this Edelweiss judgment and said that the arguments of the respondents that since COC has approved the resolution plan, the claim of the applicant have been extinguished cannot be accepted, as there is no extinguishment of claim of applicant on approval of plan by the COC. That was what was held by NCLAT. Then whether the resolution professional was obliged to include the details of home buyers as reflected in the records of the corporate debtor. Debtor in the, so basically NCLAT held that in the information memorandum, one of the words that is used is that the liabilities are required to be added under regulation 36(2)A and regulation 36(2)L. So there the obligation arises that in case there are any liabilities reflecting in the books of accounts for which claims have not been received, then these liabilities should ideally be added to the information memorandum. That is the idea.
I think, Ankit, I would just like to add, there are 2 important issues which was decided by Honorable Appellate Authority. One, that as per the present law, it is not the obligation of the RP to admit claims which are not filed. So therefore, one part is admittance of claim. But then the second part is when we read this section 36, which talks about the information, the regulation 36, which talks about the information memorandum. And in the information memorandum, the RP is supposed to provide for all the liabilities, including those liabilities for which the claim has not been filed, but it is appearing in the books of account. Now, the court says that although we are saying that it is not the duty of the RP, but who stops the RP to provide this information to the in the IM so that the resolution applicant provide for provide something for these creditors. So even if the claims are not filed, now I think in the proposed regulations as per the discussion papers, it is now, in case it is notified, it will be like the RP's duty to communicate to all liabilities which are appearing in the financial statements or books of account, but who has not filed the claims. And with that communication, the IP would be able to admit their claims. Go ahead, Ankit.
So issue number 4 was whether resolution applicant ought to have also dealt with resolution plan regarding home buyers whose names and claims are reflected in the record of the corporate debtor, although they have not filed any claim. So it says that IM ought to include the claim of those home buyers, and And in case the IM includes this detail, this detail, then of course the corporate debtor or the resolution applicant would also then treat the liabilities. So home buyers who could not file their claims, but whose claims were reflected in the record of the corporate debtor ought to have been included in the information memorandum, and the resolution applicant ought to have taken note of the same liabilities, said liabilities, and should have appropriately dealt with them in the resolution plan. In the various home buyers that we have been taking care of, or we have been looking at, we have been requesting, or rather promoting, the resolution applicant to provide for some resolution for any claims which come in belated. Because one, in case you treat them equal to the other home buyers who have filed their claims in time, it might disturb the feasibility of the plan. But at the same time, in case there is a provision that in case somebody comes up and is found later who has not been able to file his claim later and in time, that person can be given some kind of a settlement to basically seize that liability and also to address that liability. So that is something that is a good feature of any resolution plan, for any resolution plan in any case, wherever the liabilities, with respect to liabilities where the claims are not filed. So that's it. These are the judgments that we had at hand. Some questions we can take up before winding up, although we are past 7 minutes. We have a request that if two creditors combined have a claim of more than 1 crore and individually below 1 crore, can the creditors make a CIRP proceeding?
No, see, as far as the when you see this, the financial creditors can file application jointly, whereas in the case of operational creditors, the operational creditors are not allowed to file joint applications. I think the rationale behind this is that there may be a different kind of disputes for different kind of operational creditors, so those has to be dealt with separately. So therefore, they are not allowed to file joint applications. However, for financial creditors, they are admitted they can file joint applications, not for operational creditors.
So Achalji has given a suggestion, and I think that's a very, very well suggested thing that you have made, that the case name, we will try and put the case name on every slide the next time we discuss case laws. That's something that we will do, that will help everyone. The second thing that I have got is a request for a webinar on the IBBI disciplinary committee decisions on the IPs which have come in recently. So maybe we can plan something to discuss the various observations of IBBI and the caution that resolution professionals can take in their conduct for with respect to or based on the same. I think that's all the questions already taken up. We can take up questions separately, of course, later. So thank you so much, and we are already 10 minutes up, and good that we had an interactive session. Many questions that came in on these subjects, and over to you, Anand sir.
Thank you very much. I think it was a very, very big and huge attendance, and we thank all the participants for giving us this kind of encouragement, this kind of motivation. Keep joining. We actually get happy when participants join and listen to us. As we said repeatedly, there is no other objective. It is only collective learning. When we deliberate on something, we also learn. And when you ask questions, that also becomes our learning and participants' learning. Thank you very much for participating. We will try to remain connected with all of you. Thank you.
Thank you, everyone.